Okay, welcome back. Question number 2. What does legislation as such mean? Legislation as such means legislation itself, as opposed to the actual application of this legislation in specific instances. Okay, look here. Look here. Measures subject to WTO dispute settlement. Which measures can be subject to WTO dispute settlement? Here. An act or omission attributable to a WTO member may constitute a measure. All those 7, look, 1, 2, 7, or 8, 1 to 8, all these measures are in dispute, which means the members disagree with each other on whether these measures can be subject to the WTO jurisdiction. But again, because we do not have enough time, we will not go into the details for all these 8 issues. But you can always review them in the textbook after class, okay? So there are still 2 points I need to draw your attention to. First one is legislation as such. What does as such mean? As such means itself. Okay. The second one would be regional and local authorities. Regional and local authorities. Question is, can measures by regional and local authorities be attributed to the central government a member? The answer is yes. Okay. We will move on. We have to go quickly, otherwise we cannot finish this part, because for chapter 4, we've got only 3 weeks. Okay. For this chapter, we've got only 3 weeks. So we need to speed up. Okay, section 2 is about the access to the WTO dispute settlement. Access to means use. Okay. Use. Question number 1. Is EU an intergovernmental organization? Where? No, maybe it's not there. Yeah. Yes. It's not wrong. It's correct. Is EU an intergovernmental organization? European Union? Yes, right? Good, yes. Then, is it a member of the WTO?
Yes.
Yes or no?
Yes.
Yes, good. Then, so, is EU subject to the WTO dispute settlement? Yes. Okay. And the EU can access to the WTO dispute settlement system. Good. Look here. How many categories are there? How many categories of complaints are there in the WTO dispute settlement? Here. There are three types of complaint, right? One is violation complaints. Two is non-violation complaints. Three is situation complaints. Okay. So my question is, under what circumstances can non-violation complaints and situation complaints be filed? The answer is here. The words in red. There is nullification or impairment of a benefit, or that the achievement of an objective is impeded. Okay. Next question. In the case of a violation complaint, the complainant only needs to demonstrate the existence of violation. Here. What I want to say is you need to distinguish between the first type and the latter two types. There is a difference between them. The first type, violation complaints, and the latter two types of complaints. There is a difference. You need to know it. If you cannot understand it now, then leave it after class. We will move on to the next page. Okay, on this page, we've got two questions for you. First question, this is a little bit difficult, so you need to review it after class. I will not explain it. But if you read the version in Chinese, I think you can understand it. But what I would like to highlight is here about the third party. How can a member become a third party in the panel proceedings? Usually, in a dispute, how many parties are there? Two, right? Good. Very good. But there is a distinct characteristic. In the WTO dispute settlement, there are more than two parties. We've got third parties. Then my question is, how can a member become a third party in the panel proceedings? How can? The answer is the third party must have a substantial interest in a matter before a panel and has notified its interest in a timely manner to the DSB. So there are two requirements to be fulfilled for a member to become a third party. You got it? Two requirements. First, you must have a substantial interest in a matter. Second is, you must notify the DSB in a timely manner. These two requirements will have to be satisfied before a member becomes a third party in the panel proceedings. Next question, who can participate in the panel and appellate body proceedings and as an amicus curiae? Amicus curiae. Look here, amicus curiae, what does this mean? In Chinese, it's called 法庭之友. Have you got that? Yes. What does amicus curiae mean? I'll explain it in English. Listen carefully. What does an amicus curiae mean? An amicus curiae is a person or organization that is not a party to the lawsuit, but is permitted by the court to provide an opinion to the court on a legal issue directly related to the case. Got it? It is a person or an organization, but it's not a party to the dispute, to the lawsuits. But the court allows this person to provide its own opinions to the court on a legal issue. Of course, this issue is directly related to the dispute. Okay, good. That's what we call an amicus curiae. An amicus curiae. It's rather rare in Chinese domestic legal system, right? In a Chinese court, will the court allow someone who is not a party to the disputes to speak up for his own opinions? Of course not. Of course not. Good. Okay. Now let's move to section 3, key features of WTO dispute settlement. Key features. Again, this question is simple. What is the prime object and purpose of the WTO dispute settlement system? What is the prime objective and purpose of the WTO dispute settlement system? We've got one or two. One objective or two objectives. Reading comprehension, I think it's not that difficult. 朱冠平. What's the prime objective and the purpose of the WTO dispute settlement? The answer is so apparent. How many? First tell me how many. One or two? Good, two. The first one is
the permanent settlement of disputes.
good. It's enough. Okay. The second one would be
To provide security and predictability to the multilateral trading system.
okay. Good. This is security. Security. Predictability. Predictability. Multilateral trading system. Good. Okay. There are two objectives and purposes of the WTO dispute settlement system. First one in red, right? First one, second one. First one, second one. Okay. Now let's move on to next part. Does the DSM of the WTO follow the principle of stare decisis? Does the DSM of WTO follow the principle of stare decisis? This is a rather important principle in international law. Stare decisis, which means the principle of precedence. Principle of precedence. What does that mean? It's a principle followed in common law system. Yeah, good. Follow the precedents. I will explain this principle to you in English, okay? The stare decisis, listen carefully. The stare decisis is a legal principle that courts should follow previous precedents when dealing with similar cases to ensure consistency and predictability in judicial decisions. Okay? Stare decisis. So my question is, does the DSM of WTO follow the principle of stare decisis? Yes or no? Look here, this paragraph. It's rather important, okay? This paragraph, one sentence. Absent means except. An adjudicatory body will resolve the same legal question in the same way in a subsequent case, absent cogent reasons, except in exceptional circumstances, cogent reasons. Otherwise, you have to follow the previous. You got it? So, my question is, does the DSM of the WTO follow the principle of stare decisis? Yes or no? I mean, we've got hundreds of WTO rulings and recommendations adopted by the General Council. Are they enforceable, or are they previous precedents for the subsequent panels and the appellate body to follow? Maybe yes, maybe not. I'm not quite sure. But this sentence is correct. Okay, this sentence is correct. An adjudicatory body will resolve the same legal question in the same way in a subsequent case. Absent cogent reasons. Cogent means compelling, persuasive. Compelling, persuasive, cogent reasons. Okay, the last part for this part. Prevail over. Prevail over. This word is important. Why? Because the special and additional rules and procedures under the covered agreement prevail over generally applicable rules and procedures of the DSU. What does that mean? I'll try to explain it to you, okay? We've got the DSU, right? This instrument is for what? For dispute settlement, of course, right? The dispute settlement rules. But these rules are called general rules. Do you still remember in Appendix 1, we've got covered agreements, right? Covered agreements. This one is excluded. Yes? Except for this one, almost all the WTO agreement and its annexes are covered agreements. But in covered agreements, we have specific dispute settlement rules. Then, what's the relationship between the general rules and the specific rules. Which one prevail over? Which one prevails? The specific ones or the general ones? Similar like GATT and its specific agreements, right? Which one prevail? Which one prevails? The specific ones, right? Good. And also concerning the specific rules in covered agreements, there is a list also in the annex to the DSU. You can find it later after class. For example, in GATT, there are articles specifically related to dispute settlement. If there is a conflict between the general ones and the specific ones prevail over the general ones. Okay. Not that difficult, right? Because it's similar to GATT and it's a specific. It's a specific, for example, SCM agreement. This prevails, right? And this prevails. If there is a conflict between these two. Okay, move on. But there's one thing to be stressed. This DSU, together with the specific rules in covered agreements, they together form a comprehensive and integrated dispute settlement system for the WTO agreement. Comprehensive means they are families. They are an integrated whole. Okay, they complete a whole. You need not just focus on DSU. You also need to pay attention to these covered agreements because they are a complete whole. You know what? That's a completely whole. This whole. Okay, next. I don't think we can finish today's content. There's too much. We'll see how it goes, okay? Try my best. On this page, I've got I'd like to say arbitration can serve as an alternative means of binding WTO dispute settlement. You often hear about the panel proceedings, the consultations, the appellate body proceedings, but they're boring, right? They're boorish, but I have to deal with it. Consultation and panel proceedings and AB proceedings. These three are what you've heard about in the general theory course, right? Yes or no? You still remember in the Chinese course, the general theory course, we mentioned these three dispute settlement process, right? So my question is, in addition to these three processes, what else do we have? How many parties are there in this consultation? there is a legal dispute between two WTO members. First step, they have to go to the consultation proceeding. How many parties are there? These two parties, right? They consult with each other. So this is what we call, what does it look like? Like a negotiation, right? Good. Negotiation. It's like negotiation. You know, in international dispute settlement, we've got a negotiation. What else do we have? What else do we have? Negotiation. That's the first step. You still remember ADRs? Alternative dispute settlement, right? Negotiation. What else? Good office. In Chinese, we call it 斡旋. And what else? Mediation. You remember this? Mediation. In Chinese, we call it 调解. And this one. Conciliation. In Chinese, we also call it 调解. But I'll tell you, it's a wrong translation. We don't call it 调解 because it will be easily confused with mediation. But these two are different. This is called what we call 调解, and this is what we call the 调和. To distinguish between these two. Okay? And what else we have? Arbitration. All these, we call them ADRs. Yeah? Right? Arbitration. Besides these ADRs, we got court system, litigation. Litigation means legal disputes in courts, lawsuits. But these are ADRs. This is a legal dispute. The WTO proceedings, I mean these two, just like this. The panel proceedings and AB proceedings, this is the first instance of legal disputes, right? This is the second level, right? AB means appellate body. Yeah. Two instances. 二审. Two instances. First level, second level, right? In domestic legal disputes, we also have a first instance, second instance, right? Yes or no? These two instances of dispute settlement, just like litigation, domestic litigation, similar to, right? So, can we say litigation is an ADR? No, of course not, because it's not included here, right? It's here. No. Then, in WTO dispute settlement, we only got these three, consultation and litigation. What about all these methods? Are they available? The answer is yes. The arbitration also can be here. In WTO dispute settlement, we also got arbitration. Do we have conciliation? Mediation? Good office? You can find the answer here. Proceedings involving good offices. Look here. Good offices, mediation, and conciliation are confidential. Do we have them? Yes or no? Yes, good. We also have them, but they are confidential, which means they are conducted in private. No others don't know. But we have, okay? We also have these proceedings. There are so many details. So now let's come back to the arbitration. The arbitration as an alternative means of dispute settlement. Okay? There are two kinds of arbitration in the context of the WTO dispute settlement. First one is provided in Article 21.3c. The second one is provided in DSU 22.6. Two kinds of arbitrations. The first one is about what? The first one is about the reasonable period of time for implementation. The second one is about the appropriate level of retaliation. In these two circumstances, the members can resort to arbitration instead of these three basic proceedings. Okay, let's move on. You need to write down the questions I've got for you. For page 78, question number 1. What are the two threats to the multilateral WTO dispute settlement? Question number 2. Which two requirements need to be satisfied for a mutually agreed solution reached through consultations? Question number 3. What are the two tasks of the WTO dispute settlement? What are the two tasks? You still remember the mandate? What does mandate mean? 2 points. One is objective. Second is function. Then let's recall what are the two tasks of the WTO dispute settlement. Two tasks. Just now, Zhu Guanping mentioned, right? There are two objectives for the WTO dispute settlement. Then what are the two tasks? The answer is here. The first task is to preserve the rights and obligations of members. The second task is to clarify the existing provisions of those agreements. What does those agreements mean? Yeah? What do you think?
I don't know.
Then why are you laughing? Those agreements means the covered agreements. Those, of course, we'll find in the previous part. Look here, covered agreements. It first appeared here, covered agreements, then those agreements. Right? Good. The two tasks. First, preserve the rights and obligations of the members. Second, to clarify the existing provisions of the covered agreements. Okay, move on to next page. Oh. I don't even want to talk about it because I'm tired too. There are too many points here. There are only 4 minutes left. there are so many important concepts which you need to remember. First is stare decisis, right? And the second is negative consensus. And there is also an important concept. After explanation of this concept, we'll call it a day. Okay. Judicial activism. What does judicial activism mean? In Chinese, we call it 司法能动主义. What does that mean? Means, pardon? I didn't quite catch your words. Can you speak it up loudly out loud?
自由裁量
That's something similar to discretion, discretionary. But this judicial activism is not like a discretion. It's, okay, listen carefully. I'll explain it. You listen carefully. What does judicial activism mean? Okay. Judicial activism just means legislation by judges. For example, the panels and the appellate body, they are judges. They are making rulings, then they are legislating. That's not allowed, okay? The DSU allows panel and appellate bodies to interpret and clarify WTO agreement provisions, but does not allow judicial activism. WTO panels and the appellate body can neither act as legislators nor give authoritative interpretations, and they are not responsible for determining what the DSU's rules and procedures should be. Judicial activism means the judges serve as legislators. Legislation by judges. The judges serve as legislators. But judicial activism is not allowed by DSU. They cannot legislate. They cannot legislate. They can only resolve disputes, but they cannot legislate. Who can legislate then? Yes, the members of the WTO. You surprised me. You're still with me. Okay. Okay. In my view, everything is important. But I can't explain them all to you. The only thing I can do is to sigh. Okay. One more important thing is about Articles 31 and 32 of the VCLT. What does VCLT means? Vienna Convention on the Law of Treaties. Okay? And you need to memorize the contents of Article 31 and Article 32, just like the Article 38 of the ICJ statute. This Article 31 is the general rule of interpretation. General rule of interpretation. And Article 32 is about supplementary. supplementary of interpretation, supplementary rule of interpretation. General rule of interpretation. Okay, these two articles, together with this article, you need to pay more attention, because if you are an international law major student, you don't even know these three articles. I mean, Article 31, 32 of BCLT, and Article 38 of ICJ statute, then you will be deprived of the qualification as an international law major or international economic law major. Okay, you will be excluded from the group of those students. Okay. Thank you for your coming and attention. This concludes today's class, and it's the end of today's course, and I will see you next week. Goodbye for now.